I'll let you guys know shortly. Thanks. Sorry guys, I think the usual annual problem has started. Audiovisual not working. Whoever takes this job as pathway assistant, I think you're in this class, your first job is to make sure this thing works. I'll have to go to audiovisual because they don't even have a phone here to call them. Does anybody know where audiovisual is? Of course you wouldn't know. How would you know? Anyway, I'll get back and have a look, okay? I'll be back in 2 minutes.
Presentation.
Yeah.
Can you first go to the desktop really quickly? Just to... Oh, it's on.
Oh, somebody is on. No, it's not mine.
It's on.
Oh, it's on now. Okay.
There's a black screen in there.
Oh, right. Okay, so I
Yeah,
guess
you should
let
be
me
able
see
to-
what I do. Work now? Oh, brilliant. Thank you.
Should come up here somewhere. They have to put it in another slot. Some of those slots are a bit.
Don't work very well. Something is happening there. Yep. Come up now. Hang on.
I would drag it to the desktop if possible.
Yeah, it works quite well usually. I mean, I did this last week, so it worked perfectly. So hopefully it will work very well today as well. I thought somebody had switched off the whole thing and gone away. So, okay, that looks fine. Okay, now where the heck is the species? No, there it is. Nope, it's not that one. Hang on. Where the hell does it go after that?
Would be, looks like it would be that one. Is that?
I just opened it, yeah, and the species network, no. This is odd. No, it's not it.
What? I don't understand. What was the file that you had to?
Well, what I did was, it was in here, right? And I opened it. Oh, now it's not responding at all. It's somewhere in here. I mean, it happens quite often. Network, this PC, like that. No.
Is it a presentation?
Yeah.
Okay. Is that encryption?
Yeah, it's encrypted, but I put the encryption key in there. It went through, and it said yes, all okay. But now it's the actual data. Something happening. Okay. No. Desktop, no. Come your network. Empty. There it is. Wonderful.
Yeah, maybe it might be good
take,
to drag the one you want onto the desktop.
Thanks a lot for coming. The number of times this happens, it's just unbelievable. I mean, it should be able to, should come on stream virtually straight away, but it never does. Okay, now let me find. While we're waiting for this, a couple of things. Next week is reading week, but I've got to catch up a lecture, so I'll be doing the lecture next week. The seminars won't be starting next week to give you additional time to, I don't know, whatever you guys do, go skiing on Saturday and Sunday and come back on Monday or whatever. We'll start the week after. I'll put the seminar groups, which are now ready, on Keats with a fact pattern analysis to which you need to write an advice or an answer. By the time you turn up for those classes, I think it's the first Monday is the 5th of November or the 4th of November. Anybody got a calendar? Is it 5th? Yeah. So we'll start with 3 seminar groups, the group A's. The seminar groups are divided into A groups and B groups. So there's a Monday A, Tuesday A, Wednesday A, Monday B, Tuesday B, etc. Week 1, Group A will meet. Week 2, Group B, seminar groups will meet. Is that clear, or is this going to end up with 45 emails in my box? If you're not clear, hands up and ask. Are you clear? Yeah? Yeah, okay, you got a question, good.
So actually there are six groups.
6 groups.
And we are going to have tutorials every second week.
You're going to be there every second week, yes. Good. Fortnightly, yes, quite right. Right, let me go back to where I was. Okay, more questions? No? Just your neighbor's telephone number. No, it's all right, go ahead. About the Okay, let me backtrack. Next week, see what I mean? People wake up and think, what was he saying? Next week, there's only a lecture. Wednesday, 3 p.m. as usual. Nothing else. The week after, the seminars commence. That week, only the Group A groups will meet. Monday, Tuesday, sorry, not Monday, Tuesday, Wednesday. Nope. Oh, right, you want to ask a question about the lecture? Fine, I thought, oh no. Right, go ahead, please. Do go ahead.
Last time we learned that apart from the structural application with that sort of law, but in Article 14, where that the choice should be expressed or demonstrated with reasonable certainty, the decision of the case and should not set the rights of the parties. So what I'm asking myself is, if we look for certainty and predictability in those contracts.
Do you want to speak up so everybody can hear? Because they are now back to Facebook.
If we are looking for predictability and certainty,
Yep.
isn't the term reasonable and also what does it mean prejudice to the rights of third parties?
Anybody got the article in front of you? Have you got it in front of you? Which is article, what I was talking about was sorry, hang on. Non-contractual obligations, and what I said to you guys was Article 4.3. 4.3. Now have a look at 4.3. What does it say? It doesn't have to be reasonable. It is simply choice given to the parties to specify with an express clause what law they would like to apply to any delicts, torts, civil wrongs that arise in relation to the transaction. Okay? So it provides a much clearer framework to cover the problems that arise in the context of a transaction where a civil wrong has been committed. Usually it's to do with, in our world, it's to do with misrepresentation, misinformation being given. And in the past, you had to fall back on things like lex loci damni, lex loci delicti, and all that kind of stuff. That, although it's there in the legal framework, Article 4.3 gives everybody an opportunity to choose. Now, like everything else in real life in the markets, you look for certainty, and that's what you get. Article 4.3 clauses in relation to every transaction. Yep. Anybody else wants to think about it? All clear? Okay. Can we move on from there unless you got any more questions? Let me just try and I can see a whole pile of, I know it's a difficult area. It's not only difficult, it's also technical. It combines the worst of both worlds. It's a very technical area. Unfortunately, we need to come to grips with it before we go into syndicated loans or bonds or whatever. Because this stuff underpins how syndicated loans or bond issues are structured. So to that extent, I think you do need to come to grips with this stuff. I'm just going to summarize it in 5 minutes so you get it clear in your head. What we're trying to do with this choice of law process is to try as far as possible to control all aspects of a transaction by reference to a single system of law. We can't always achieve it, but it is the only means that global law firms have developed to control the potential applicability of a whole range of law systems because the transactions are multi-jurisdictional. And that process is what we've been talking about all this time. And the most common version is the express choice of law clause to control contractual aspects. Now, how do you go about it? That depends on, as I said last week, two really important factors. One, the chosen law system must tell you, well, if you choose this law system, what will it control? What will the law system control? And in that context, I took you into Rome 1, which is the best model of what a law system can control, because it's now codified in Rome 1. It's a whole range of things, from essential validity to interpretation to whether performance is being given and so on. All of that is codified in Rome 1. It's the most advanced version of a law system's control when there's an express choice of law clause. The second thing I pointed out to you guys was it's not enough for the law system to say, hey, yeah, you can control all these things if you choose my law system. But it won't help if you choose Iranian law or North Korean law, because it may not be recognized in other parts of the world. So recognition by other law systems of the chosen law is also fundamentally important. And that's why we looked at the recognition rules, which once again, the EU Model Code, I shouldn't say code, it's not just a code, it's a regulation, which is binding on all 27 states, provides a very clear-cut principle. You choose a law system under Article 3, and all law systems across the EU must recognize it, full stop. Now, you don't get anything as clear-cut as that in other law systems. If you go to the New York law, the applicable rule is contained in the American Restatement. Now, yes, the reasonable connection with New York law requirement is gone, but nevertheless, it doesn't have the clarity that the EU code contains. You've got to go into New York case law to work out what the heck, when you choose New York law, what does it control? Secondly, if you choose New York law, there's also another question: what is the recognition given to New York law across the globe? Now, in the EU, it's easy. You've got your Rome 1. If you choose New York law, in the EU, there will be recognition given to the chosen law. Go to Singapore, go to Hong Kong, what do you have to do? Or go to China, answer. You need to look at the conflicts of laws, rules in that country to work out whether New York law, indeed English law, will be recognized. But those are the two things you work with in order to try and insulate a transaction from the applicability of so many law systems. But please do remember, and this is the fundamental, that although that is the only available route in practice to insulate a transaction from a whole number of applicable law systems, it doesn't control everything once you choose that expressly chosen law. And I think I walked you through a whole pile of things, like corporate capacity, internal vires, birth and death of corporations, which are not controlled by that expressly chosen law in a transaction. These things are controlled, the first three on that list are controlled by the law of the place of incorporation. Go one stage further, if you look at transfer of assets, it's not the expressly chosen law, it's something else. It's the lex situs of the assets, i.e. where the assets are located. Then there's the applicability of securities laws in relation to securities transactions like bonds, MTNs, GDRs, etc. Then you've got the most powerful overriding law, which overrules entirely any decision that you can come to on the basis of the chosen law, and that's insolvency. So if a counterparty goes insolvent in the context of a transaction, well, all your beautifully drafted documents with this chosen law simply will be put aside, and all that will matter is the insolvency regime applicable to that bankrupt counterparty. So the point I'm making is, therefore, there's a whole number of things which are not controlled by that chosen governing law. And then we looked at other things like non-contractual obligations, which are not controlled by that expressly chosen governing law. And it's there that we got onto the Rome 2 question, because Rome 2, for the first time in any set of legal systems, has given the power, the legal ability, for a party to say, if there's a tort, a delict, or civil wrong in relation to this transaction, it will be controlled by the law system that we now specify in this document. That's the first time it's happened. It's the only law system which enables it to happen. It doesn't happen under any law system in the US or anywhere else on the planet, at least as far as I'm aware. So this is a huge new innovative development in the law. So we've got that to control torts, delicts, and civil wrongs. Now, there are other things that also fall outside the chosen governing law. One is this thing called unjust enrichment, which is where a party acquires a financial benefit in the context of a transaction which it should not have got under normal circumstances. Usually happens because of a mistaken transfer, a mistaken payment, and the like. That, again, is outside the control of the governing law of the transaction. We had another area which is outside the control of the governing law of the transaction, namely things that happen prior to transaction documentation being signed and becoming legally effective, i.e., during the negotiations phase. Something happens, negotiations break down, parties walk out. What then? Under English and New York law rules, the answer was very simple. In practice, you'd have had a document which said all negotiations are subject to contract. Namely, under English and New York law rules, that meant one thing and one thing only. There are no legal obligations until the actual final documentation is signed, sealed, and delivered. But that wasn't true, say, under German law, or Italian law, or French law, or Japanese law. And therefore, we had uncertainty about what happens in that scenario. That, at least as far as the European Union is concerned, we have now got a new rule contained once again in Rome II, which says if negotiations break down due to the fault of one party or another, and documentation isn't signed, isn't finally signed, nevertheless, the law which was intended to be used by the parties in that documentation will control whether or not there's liability for breakdown in negotiations, what is called in usual Latin format, culpa in contrahendo. So we've got something else that's now come into place to control what happens before transaction is signed, sealed, and delivered. That means that if you've got a New York law-controlled agreement or an English law-controlled agreement intended to be signed under English law or New York law, and the negotiations break down, under the EU rule, what happens is you look to work out which law would have controlled. And if English law or New York law was intended to be used, that law will control whether there's liability for breakdown. Now, how do we know what law system was going to be used for the final documentation? Answer that I gave you last week is that in practice, every transaction has got heads of agreement. It's called a term sheet. It's a summary of what parties hope to agree, intend to agree, but not yet agreed. But in there is a very vital fundamental provision which says documentation to be signed shall be subject to XYZ law. So if it's under New York law or English law, what happens? The old rule of no liability until the final documentation is signed will apply under Rome II, which creates once more certainty. So those are the parameters under which we work. There's one thing I didn't actually talk to you about, and I think I'll just add it in. I've been talking about Rome I and Rome II. But that's not the end of the story, because if you look at what happens in relation to Rome I, it applies only in relation to transactions or contracts entered into after 17th December 2009. Yeah, in your mind, geez, that's ancient history. True. But there are huge numbers of huge transactions which have been signed long before 2009 and which have a lifespan of over 25 years or 30 years. Question, what happens there? Well, Rome regulation does not control, neither Rome I nor Rome II. So what does? Well, the answer to that, which I didn't talk to you about last week, and I thought I'll leave it for later, is this. There is a convention, again in the EU, which applies prior to the Rome regulation being enacted. That contains what happens when you choose an express law system. What it says is if you choose an express law, express governing law by an express clause, then countries which are party to the Rome Convention will apply that law system across any country in the EU, subject to two exceptions. Article 3.3, which is very similar to the provision in the Rome regulation, Namely, if all of the elements of a transaction are connected with a single law system, then that law system will apply. And as you know, as you should know, that doesn't apply for purposes of transactions in this class. These are all international transactions. By definition, they're not tied to one country or law system. But there is another one, and this is really important for transactions prior to 2009. Article 7.1 says if there is a law system which has got a close connection with the matter in question, i.e. the transaction in question, that law system will override the expressly chosen law system. Now that's a huge hole in the control of the express governing law, because it is subject to this exception. Now, the way that rule was implemented is that the United Kingdom government expressly excluded the application of Article 7.1. Because if you choose English law to be governing law, Article 7.1 has no application. So if the transaction has a close connection with another law system, so what? It doesn't matter. It's not part of the English law which has been chosen. That happens due to all these articles that I put there. It's contained in the Applicable Law Act 1990, and Article 7.1 of the Rome Convention does not apply. Stop there for a second and ask the next question. Well, what happens under German law, French law, Italian law? Answer, yes, Article 7.1 does apply. And therefore, in relation to transactions before 2009, if you chose German law, or you have chosen Italian law for the transaction to control it with an express choice of law clause, if that transaction has a close connection with another country or law system, say Japan, Article 7.1 says you will give effect to that other law system. You don't have to do that if you choose English law, because English law expressly ruled out, excluded the application of Article 7.1. This has got a very important ramification when we come to look at what I'm going to look at today in detail, something called moratoria and sanctions. So I'll talk you through that in detail, because the way English law goes and German law goes or Italian law goes are different. Your question, please.
What is considered a close connection? Is it enough that just one party is foreign?
Good question, because that is something that is not defined in the EU Rome Convention. It is a concept which is found in New York law as well. And the problem is, because it has no definition, every choice of law in every transaction document will be subject to uncertainty, because you may have a court saying, oh yeah, this has got a close connection with this other country because payments are going through that country. We don't know is the straight answer. Thus, due to a lot of pressure from investment banks and commercial banks and others, not to mention hedge funds and so on, and the global law firms in London, they pushed and got exclusion of Article 7.1 into English law. Didn't apply for that very reason, because it introduces uncertainty. But that doesn't happen under German law, in French law, because that uncertainty remains. But remember, it's only for transactions before 2009. We've got Rome regulation, which has got rid of this dreadful close connection rule. What Rome 1 has got, as you remember, it has got rid of the close connection rule, and it simply introduces the Article 9.3 rule saying the expressly chosen law can only be overridden by the law of the place of performance and its mandatory rules, nothing else. So to that extent, the law is one heck of a lot better under the Rome regulation than it was under the Rome Convention. Okay, if you don't have any further questions, I'm going to move on to talk about things other than culpa in contrahendo and torts and civil wrongs which fall outside the control of the governing law. And in that context, we have something else which is a really difficult question, namely this one, the lex monetae rule. Everybody started looking at this lex monetae problem because of Greece. Because at one time, it was thought that Greece might say, that's it, you guys have behaved very badly, I'm getting out of the European Union, I'm getting out of the Eurozone, and I'm going to re-adopt my old currency, the drachma. So what happens now? There are a whole number of Greek transactions, Greek obligations, owed in euro. But the Greek government says, right, that's it. From now on, we're not paying, except in Greek drachma. Question, what is the impact of the redenomination of the currency of Greece from the euro into a new currency, say, new drachma? It's not the first time it happened. It happened when, the best known example, when the Deutschmark, the French franc, the lira, and all the currencies of the European Union disappeared and was replaced by the euro. Now think of all the bond issues, think of all the syndicated loans which were denominated prior to the introduction of the euro, which were denominated in lira, Deutschmarks, French francs, and the like. What happened to them after the euro was introduced? The answer takes you right back to this so-called Lex Monetae rule. It also happened way back after the First World War, I think, where there was, it was after the Second World War, where the Reichsmark was denominated obligations were attempted to be converted into Deutschmark obligations by the German government. Now, it can happen again. Scotland may pull out of the United Kingdom if the United Kingdom leaves the EU. I'm not saying it will happen, but the Scottish Parliament has been saying, we want to get out of this thing. Out of the UK, that is, if the UK gets out of the EU. Now, pound sterling is the currency of Scotland at the moment. Assuming Scotland leaves, what happens to obligations of Scotland denominated in pound sterling? Once again, you're back to the Lex Monetae rule. So what does this Lex Monetae rule say? What the Lex Monetae rule actually says is that if a country designates a new currency in place of its existing currency, then the new currency that they've designated, new drachmas or the Scottish tartan or whatever you want to call it, will be substituted for the existing obligations in the old currency. So to go back to my Greece example, if Greece had left the Eurozone and redenominated its obligations, bond obligations, loan obligations, from euro into new drachma, the new drachma would be the currency of the obligation. And in other words, there's a change in the currency of obligation because of the change in the government's adoption of a new currency in place of an old one. This took a huge amount of thinking because everybody knew that Greece might have just done that because they were so fed up with the way the EU was dealing with them. But it transpires that, in fact, the Lex Monetae rule under, well, it's called international law. I'm not even sure it is international law, but the Lex Monetae rule would apply to redenominate obligations in one currency into a new currency only and only if the old currency ceased to exist. Got it? So let's go back. Take Greece. Euro-denominated obligations. Greek government says, that's it. Euro is no longer the currency of Greece. We're adopting new drachma. Does the Lex Monetae rule now enable all obligations of the Greek government to be redesignated in new drachma in place of euros? Answer was no, because the Lex Monetae rule wouldn't apply because it only applied where the old currency ceased to exist. The euro doesn't cease to exist. The same answer is given assuming Scotland pulls out of the UK. obligations denominated in pound sterling would remain because pound sterling as a currency has not been terminated or abolished. So while the Lex Monetae rule is important and does override the control of the governing law, it only applies in this restricted area where the old currency of the country ceases to exist completely. That won't happen in Scotland, and it certainly wouldn't have happened in Greece if Greece had decided to leave. Any questions? Yeah.
When it comes to redenominating, is it just all the obligations, say the obligations of a million or whatever in a transaction?
Couple of million?
Is that just converted, but what exchange rate needs to be?
Well, if take an example, if you had a conversion of Deutschmarks, French franc, lira bonds in, when the heck was it, 1990, into the euro, it would have been converted at the designated rate of conversion. So everybody agreed then, way back in 1990, that Deutschmark obligations would convert into euro obligations at a given rate. Lira obligations would convert at a given rate, and so on. So that's what would happen. In that same structure would happen if, for example, Greece were to convert from euro into Greek drachma. Okay, anything else? Yeah.
Where is this rule laid down?
That's a very, very good question. Where the heck does this rule come from? Well, that's a difficult one to answer because it's not a rule of public international law. It is regarded as a rule of private international law, and logically, therefore, it must be a conflict of laws rule to be found in every law system. And that is the conclusion of the major book on the subject, Dr. F.A. Mann's Legal Aspects of Money. I think it's in my reading list if you want to just, don't read the whole book, it's quite thick. But that's the conclusion that he comes to after a rather detailed analysis of it, that it's actually a rule of private international law, not public international law, therefore conflict of laws rule within a chosen law system. So if you choose New York law, the Lex Monetae rule would be applied under New York law. You choose German law, the Lex Monetae rule would be applied under German law. Thank you. That was a very good question. I was going to deal with it at seminars, but you raised it, so okay. Yeah, back we go.
When we're talking about all currencies cease to exist, like if, for example, in the case of Scotland, England, Wales, and Northern Ireland would like to help Scotland with a new currency, would they have
Help?
If they just rename pound sterling to a different currency?
Oh, they would. Scotland could quite easily say all our pound sterling obligations we redenominate. I pick tartan, but it could be whiskey. It doesn't matter.
I'm just saying, what does the cessation means? Like if they rename the currency, or if they change the foreign exchange, they just say £1 is equal to the new pound, is equal to one new pound. Would that be a change of currency?
Of course it would.
The old pound would be ceased to exist.
Absolutely.
So
Well, it doesn't, hang on. Wait. The old pound doesn't cease to exist because in England, Wales, it would continue.
What I'm saying is that then England, Wales, and Northern Ireland decide to change their pound sterling to the new pound sterling so that they help Scotland redenominate, and then they just rename the currency.
Okay, if you got a new currency in the United Kingdom, excluding Scotland, then clearly the old pound doesn't exist anymore. Therefore, Scottish redenomination into the tartan or Scotch whiskey would be operative. Okay, we'll explore this at seminars in more detail, but now I'm going to get on to something else, which is part of the problem of trying to control all aspects of a transaction by a governing law. And the two things that interfere quite regularly in global markets are things called moratoria and sanctions. What's a moratorium? Well, a moratorium is a legislation or regulation or a decree of a government usually a government in financial difficulty, by decree suspending temporarily could be 7 years, temporarily suspending all payments denominated in a foreign currency owed to banks, bondholders, investors, hedge funds, and all foreign counterparties, which is what, as you will know, Argentina did. That no payments to foreign creditors of any kind to be made in dollars or any other foreign currency until further notice. It's a long time since Argentina did that, but it's a temporary suspension. Greece threatened it but didn't do it, to impose a moratorium, saying we're not going to make payments in euros, but they did not implement it. Now, many people think this is an exchange control regulation. In one sense, it is. An exchange control regulation, which many countries have, whether it's China, whether it's India, whether it's Brazil, it's a regulation which says you may not move currencies out of this country as and when you please. You need permission, or you're subject to certain restrictions. The US doesn't have it, the EU doesn't have it, Japan doesn't have it, but many other countries have exchange control regulations. Now, exchange control regulations pose a different problem for international finance from a moratorium. Why? Because an exchange control regulation is one which exists, actually exists, at the time a transaction is entered into. A moratorium is a regulation or decree which is enacted after a transaction has been entered into, seeking to interfere with the payment obligations in that transaction. Now, if you think about it, if you're doing a transaction in Kazakhstan today, anybody from Kazakhstan? No Kazakh lawyers. Okay. Say you're doing a mine financing, a gold mine financing in Kazakhstan for Kazakhmys. Well, you can't just walk in there and say, hi guys, here's $400 million and 500 million euros. You can't. For Kazakhmys to borrow that money, it needs exchange control permission. That's true of most countries. Well, I shouldn't say most countries, a large number of countries. That's easily handled. Before the transaction is entered into, Kazakhmys would go to the central bank and say, please, may I have permission to enter this transaction and borrow dollars or euros. Consequently, when we do syndicated loans or bonds, you will see that there is a specific clause in every agreement saying if exchange control permission is required, you will obtain that exchange control permission before you enter this transaction, and you will supply proof of the giving or the obtaining of exchange control permission from the central bank. Easily handled. They don't get it, they don't get the loan, they can't do the bond issue. It can be dealt with quite easily. But that's not the real problem. It's not exchange control which is the problem. It is the problem that, first of all, if you have a scenario where Kazakhmys enters into a transaction, borrows 800 million, and then the Kazakh government 4 years later says, okay, no further payments can be made in dollars by Kazakhmys, or indeed any Kazakh corporation, to anybody else outside this country, or indeed in this country. That's a moratorium. That's what Argentina did. That's what Russia did. Excuse me. I think yeah. So that's the difference between exchange controls and moratoria. Moratoria occurring after a transaction is entered into. An allied problem are sanctions. Sanctions. Sanctions, you're probably familiar with it already. There are US and EU sanctions operative in relation to Iran and Russia. The Iranian sanctions are far more extensive than the Russian sanctions. And basically it imposes penalties for anyone lending, engaging in financial transactions with the designated country in question. i.e., you may not lend, you may not borrow, you may not repay, you may not do anything with the designated country. That's a sanction. Now that's different from the moratorium. Because this one simply says the government of the United States or the governments of the EU will impose penalties if you enter into a financing transaction or indeed a trading transaction with Iran, for example. The objective is different. In the case of a moratorium, the reason why the government is imposing a moratorium is to conserve foreign currency because it's in the country is in financial difficulty, to conserve its financial reserves. That's the purpose of it. And they are usually imposed by countries which are in financial difficulty. Sanctions are exactly the other way. They're not imposed by countries with financial problems. They're imposed on countries by very rich and powerful countries like the US trying to change policy in some part of the world. So that's different. The concept is different and the rules operate differently. So let's try and see how this thing works now in relation to transactions, sanctions and moratoria. Anybody have any questions? Yeah. Oh, sorry, I knew there was a question somewhere. Go ahead, please.
I had a question about the exchange rate and the moratoria.
Okay.
I didn't really understand what's the problem about exchange control during transaction because if it's concluded before we are entering into control, we are like a year of it being imposed. Yeah.
Argentina is the classic example of it. It's a classic example. Sorry?
It's about moratoria.
Argentina is a moratorium. It's been a 10-year moratorium. And the regulations in Argentina prevent the Argentine central bank, the Argentine corporations, Argentine banks from making any payments in dollars or euros.
Yeah, it's moratoria.
That's a moratorium.
In terms of exchange, I understand that there is a difference and big difference, but if there is an exchange control, then what happens? Like when we are signing a contract.
If you want to enter into a transaction,
Yeah.
whether it's a bond issue, securitization, or syndicated loan, and that's why I took the example of Kazakhstan, where there are exchange controls. Kazakh corporations cannot borrow foreign currency except with the permission of the central bank.
So
Right.
we know it.
So we know what it is.
Yeah.
And therefore, we require the party entering into the transaction, which is subject to exchange control regulations, to say, right, you go get exchange control permissions or you cannot do this transaction. So that can be dealt with it very easily. Moratorium is a different ballgame because the transaction has been entered into and now you've got a problem, which you can't deal with by anything else other than looking at the law in question and what law controls. Because now you've got, for example, in Argentina, all its bonds and all its loans are controlled by New York law. The moratorium is under Argentine law. Question, how effective is that moratorium? Same question arose with regard to Russia, 1989. Russian bonds, Russian loans, Russian derivatives, subject to English governing law, were subject to a Russian moratorium. Question, what was the impact of that legally? So we need to think about that in the context of chosen governing law. Is it effective or is that it? Does the moratorium override? So let's look at that question in a bit of detail, okay? Now, the usual places that moratoria emanate from, they're not just the country where a borrower is incorporated. It could be the place of business of a borrower or counterparty in a transaction. It could be, and this is the crucial one, emanate from the place of performance. The moratorium could be part of the law of the place of performance. Now, if you just step back a little bit before we look at sanctions and look at the rules applicable, you'll see that there is a difference now if you look at the old Rome Convention rules based on close connection and the new rules under the Rome regulation and indeed common law rules contained in the American Uniform Commercial Code, which restricts the override to place of performance. Because the question that arises in relation to a moratorium under the old close connection rule was the Argentine moratorium subject to Argentine loans and bonds subject to New York law, express clauses. Could it be overridden by Argentine law? Well, it depended on whether you were using the rule regarding unlawful by the law of the place of performance or whether or not there is a close connection of this transaction with Argentina. Because quite clearly, all those transactions had a close connection with Argentina. Therefore, if you applied a close connection rule contained in Article 7.1 of the old Rome Convention, pre-2009, the answer was clearly yes. Therefore, if there were syndicated loans or bonds governed by German law, Italian law, the Argentine moratorium would need to be given effect to because transaction had a close connection with Argentina. That wouldn't have happened under English law because English law excluded the operation of Article 7.1 of the Rome Convention. So there are differences which one has to bear in mind moving on. Sanctions and moratoria. Next question. Yeah, somebody had a question? No, I'm done. So what is it that we have to think about? One of the reasons, and I mentioned this when we were talking about the choice of law process, why English and New York law, one other reason the markets favor these two law systems is because these two law systems, unlike most other law systems, take an extremely aggressive attitude towards moratoria, essentially refusing to recognize moratoria if New York law or English law have been chosen as governing law. Recognition is denied by New York law, recognition is denied by English law to the moratorium, unless it happens to be the place of performance. So the Argentine moratorium, for example, would be denied recognition as it has been all along by New York law. Argentina has been compelled to make payments by New York courts in relation to New York law-controlled bond issues and syndicated loans, even though there's an Argentine moratorium demanding and requiring Argentine corporations and the Argentine Central Bank not to make any payments in dollars. That's the old rule. Unless it is illegal by the law of the place of performance, one is required under English and New York law to ignore the moratorium. Now, as you might have guessed, if you ask the question, what is the place of performance for Argentine loans in dollars, Argentine bond issues in dollars, Argentine derivatives denominated in dollars, the answer is absolutely straightforward. All the documentation says place of performance, New York. So under New York law, Argentine law becomes irrelevant. And it is also clear law, both under English and New York law, that the law of the issuer's place of incorporation or residence is completely irrelevant. That was established long ago in the cases involving the investment bank Kleinwort & Sons long ago with a number of German companies in 1939. And also, of course, you came across this in the Greek bank cases, which I talked about last week. So, the only override now is the Article 9.3 override. Namely, although you've chosen New York law as governing law, or English law as governing law, the moratorium imposed by Argentina or any other country, Kazakhstan, for example, or Russia in 1989, will only be given effect to if that law, Argentine law, Russian law, is the law of the place where the obligations, the payment obligations have to be performed. And in practice, as I pointed out to you, it is usual, inevitable practice that you never have the place of performance in the borrower's or issuer's home state. The place of performance in practice in all documentation is usually expressly made to be in a major financial center. Tokyo, New York, London, Frankfurt, wherever it is, Singapore, wherever you want to go, where you won't expect the moratorium to hit. But these are important problems because, I mean, the Argentine moratorium of 2002 actually affected $155 billion of obligations, all subject to New York law. And because they were enforceable in New York and not in Argentina, New York court said, no, they're all enforceable. Argentine law is irrelevant. So what you get, because of this governing law rule, is essentially a firewall between the transaction and governmental moratoria. It can't penetrate unless there is a place of performance which is inside the country where the payment has to be made. Without it, all other moratoria become irrelevant. Okay, I'm not going to go into all the detailed cases. I explained this Rome Convention difference about close connection before 2009, that the Rome Convention operated differently whether you chose German law, Italian law, French law on the one side, or English law on the other. And I made the point that Article 7.1, which makes a law system with which a transaction has a close connection applicable, under Article 7.1, being excluded as far as English law is concerned. I think you're all now clear on that. Right, we all know that about practice, about loans, bonds, and derivatives. Always specifies the place of performance outside the country in which a moratorium is likely to be imposed. Now comes a slightly more technical point, which I'm going to deal with. We've talked about, sorry, did you have a question? No, you're okay. We've talked about the law of the place of performance rule under Article 9.1 of Article 9.3 of Rome and under the old common law rules of recognition of the law of the place of performance, which is true of New York law, true of Canadian law, true of a whole number of other law systems. The question that we now have to drill down into is exactly what do we mean when we say the place of performance? This is something that's relevant to Article 9.3 of Rome today. What is the place of performance? Well, it's easy when you've got a single act of performance. Money has got to be paid in New York or in Tokyo. That is the place of performance, where payment has to be made. And if the payment is illegal where it has to be made, then Article 9.1 and the so-called place of performance rule requires that payment not be made. And that governing law will recognize the prohibition by the law of the place of performance. But that's not the end of the story. Because performance may be just one simple act of payment, but it could be wider than that. And the problem is, when a payment to be made necessarily involves activity in more than one country, how does the illegality, the law of the place of performance rule apply? There was a case decided which looked at this question because it is not always easy to decide exactly what constitutes performance. Is it simply the payment of a payment obligation, or is it wider than that? And I'm going to take you to the Libyan Arab Bank case and tell you what happened. You ever hear of a man called Reagan? Ronald. Film star. Starred in a great movie called Bedtime for Bonzo. No? Never seen it? Gee, you got to watch that movie. It's about a chimpanzee whom he looks after. And of course, 20 years later, he was president of the US. Not the chimpanzee, but the actor. Anyway, Mr. Reagan was president of the US. And he and another gentleman whom you may have heard of, a certain Mr. Muammar Gaddafi. No? Name doesn't ring a bell? Never heard of him. Golly, okay. Wow. He's dead, so. Murdered by his own people during the so-called Arab Spring. Anyone from somewhere down in North Africa or thereabouts, the Levant? No one. Okay, so you never heard of Colonel Gaddafi either. God help me. Okay, right. Anyway, the point I'm making is that way back in ancient history, in 1986, the United States government and the Libyan government, as usual, were having a contretemps. And what the American government, the US government did was imposed an asset freeze on all movement of Libyan assets. Now remember, this is not a moratorium, it's a sanction. Now let's put this in context. Okay guys, I'm going to stop till people have cleared their minds and got answers from their colleagues, neighbors. Did you get the answer? No? Okay. I'll move on. Here's the factual background to the Reagan freeze. American corporations, for example, American Airlines, were buying oil from the Libyan government and Libyan corporations. There was therefore a huge dollar flow from companies like American Airlines to Libyan oil companies. The Libyan oil companies required payments by American Airlines and similar to be transferred to an account in New York with a bank called Bankers Trust, which I'm sure you have not heard of. Why? Because Bankers Trust was eaten up one morning by the mighty Deutsche. But it existed then. The Libyan oil companies had accounts with this US investment bank, Bankers Trust, in New York. And they required all American corporations having to make payments for oil to transfer the monies to this account of the Libyan Arab Bank held with Bankers Trust New York. That account, which is the US dollar account, was governed by New York law. But at 2 p.m. every day, absolutely every day, all funds lying in this account had to be transferred out of New York to London, to an account of Bankers Trust held in London. Now you know why that is, don't you? Or have you forgotten already? As a matter of market practice. Why are they doing this? Why were they doing this? Because it's market practice, not for lack of a better word. I hate that word. Middle Eastern corporation. I mean, Libya is hardly in the Middle East, it's North Africa. To move their funds out of New York into Europe, usually London. That practice resulted in this transactional structure. At 2 p.m., all funds lying in the account of the Bankers Trust New York for the Libyan Arab Bank would be transferred across to London. On 4 p.m. New York time, 8th January, President Reagan imposed an immediate freeze, effective 4 p.m., as it was announced, on all Libyan assets and all Libyan accounts within the United States of America, and all Libyan assets and Libyan bank accounts globally, held by US banks, i.e. no payments, no movement of funds lying to the account of Libyans with US banks, whether in New York, whether in London, whether in Singapore, or wherever, could be transferred to the account holder, namely the Libyan Arab Bank. When it happened, when this thing was announced, there was in fact, oh yes, there it is. There was $165 million which was lying to the account of the Libyans in New York. There was $131 million lying to its accounts in London. Now, oddly enough, the $165 million should have been transferred at 2 p.m. But for some reason, which we are not familiar with, Bankers Trust didn't make that transfer, and 2 hours later the Reagan decree froze those funds. And Bankers Trust said to the Libyans, sorry guys, Uncle Ronald Reagan has said, I can't pay you. The funds are frozen. Not only that, I can't pay you out of my London account either, because those are frozen under the Reagan decree. So the Libyans were obviously very unhappy, and they sought to recover the funds lying in the London account and the New York account by bringing litigation in London. Now the English courts, sorry, I forgot to mention one more thing. That was controlled by English law, that was controlled by New York law. So what the court had to decide was the Reagan decree effective? The US governmental decree effective? The sanctions imposed effective? Well, what the court said was, well, it's effective as far as English law is concerned, insofar as the account is controlled by New York law. New York law, Reagan decree, effective. But in relation to this account, English law as expressly chosen law controlled, all other law systems were irrelevant unless the place of performance was in America. Question, what was the place of performance of this obligation owed by Bankers Trust to the Libyans to pay $131 million from that account when the Libyans asked for it? Well, most people would have said, well, isn't it obvious? It's London. So the US decree is irrelevant. But that was not the end of it. There was a number of rather complicated arguments which were presented and which would be useful to just think about. The first argument was this one. It was argued on behalf of the Bankers Trust that if you had an obligation denominated in US dollars, that obligation existed only within the United States. Even though the account was in Singapore or London or wherever, the dollars never left the United States. Therefore, the place of performance was always the home state of the currency. That was rejected by the court. Said, no, that's not correct. It may be true in terms of economics. That's not the law. The performance of an obligation, the court said, was not necessarily located in the currency of the country of that currency. So US dollar obligations could exist outside the US. Second one is the one that I wanted to get to, and that is, what was the performance that was required? Was it simply the payment of the dollars by Bankers Trust to the Libyans in London? Obligation in London to make the payment. That would have ended the matter. The lawyers for Bankers Trust said, no, wait a minute, that's not as easy as that. Because in order for Bankers Trust London to transfer the $131 million to the Libyans, the only way you could do it is through a series of electronic instructions given by Bankers Trust London to Bankers Trust New York, which would have given instructions to, say, Bank of America, that's an example, to transfer the $131 million to Libyan Arab Bank. And how would they do that? By requiring the Libyans to say, where do you hold your dollar accounts? Answer, say, Swiss Bank Corporation. Swiss Bank Corporation holds its dollar accounts at JP Morgan, New York, for example. Therefore, the funds transfer, in effect, can only happen with the account of JP Morgan in New York as ultimately the account holder for the Libyans, and Bank of America as account holder for Bankers Trust London. Both those accounts are held with the Federal Reserve Bank of New York, located in New York. Therefore, in order to make the transfer from Bankers Trust London to the Libyans, the only way it could be done was to go through the Federal Reserve Bank in New York. Therefore, said Bankers Trust, it's an act necessary for performing our obligation to make the transfer of the $131 million to Libyan Arab Bank, and that can only be done in the United States. Law of the place of performance applies. The law is US federal law, and there is a sanction saying you will not make the payment. Therefore, under English governing law in relation to that account, sorry, this one, where is it? Whoops. English governing law in relation to that account, the place of performance, because of the payment system, was actually in New York. I know, it's terrible, isn't it? The look of what's he talking about. I can see, it's amazing what you can see from here. What is he talking about crosses so many faces. And I always think, well, why don't you raise your hand and say, what the heck are you talking about? Which is what I would have done to my professor when I was a student. So, the logic of the argument was that it's not simply the payment in London that matters. It is every act absolutely necessary to enable that payment to be made in London. And that includes transfers via the Federal Reserve Bank electronically through accounts held by banks within that Federal Reserve system. So what did the court have to say about it? The court said, no, that's not right, because this is the use of the Federal Reserve Bank system for making the transfer was possibly the most convenient, but it was not the only means of making the transfer. It was quite a funny comment by the lawyer arguing the point. He said, well, what are we supposed to do? Put dollars into wheelbarrows and take it across to the Libyan Arab Bank? How else are we supposed to transfer $131 million? But the court said, no, there are other ways of doing it, and this is not the necessary system of transferring funds. Therefore, said the court, Bankers Trust in London was obligated, mandatory, to make the payment in dollars to the Libyans in London. That was the conclusion of the court. It went one step further. The US was very annoyed about this. Remember, there was $165 million which had not been transferred by Bankers Trust at 2 p.m., as it should have, to Bankers Trust London. Court said, that $165 million is also recoverable. Even though the account is controlled by New York law, the obligation is owed to an account in London controlled by English law. Therefore, there was a breach of an obligation under English law for the transfer of $165 million at 2 p.m. New York time. Consequently, English law controlled the right of the Libyan Arab Bank to receive the $165 million at 2 p.m. And since Bankers Trust did not perform that obligation and transfer it to London, Libyan Arab Bank could recover it by way of a claim in damages against Bankers Trust. Needless to say, I mean, the Americans weren't very happy about it. But the whole thing was settled, needless to say, by extra legal and judicial methods. Namely, the Reagan government said, okay, we'll just allow you to make the payments in London, exception to the regulation. And the problem, therefore, didn't arise. Because otherwise, if you thought about it, what happened here was essentially that if Bankers Trust complied with the UK court order, there would have been breach of the Reagan regulation. Directors go to jail. If they complied with the Reagan regulation and ignored the UK court order, contempt of court, the directors go to jail. So either way, they would have gone to jail. That's why there had to be some kind of sensible compromise which was achieved at a political level rather than at a legal level. But the important point for us is this concept of where is the place of performance. It's not always easy to say, that's it, payment in London, London's the place of performance. And at least one thing is now clear. The payment mechanisms of any major currency, which are located usually at the central bank of that currency, Frankfurt for euros, Tokyo for yen, Federal Reserve New York for dollars, is not the place of performance necessarily in relation to payments in that currency. The place of payments, therefore, depends on the legal provisions in transaction documentation and not on the payment mechanisms in relation to the currency in question. Are we clear? It's a major rule that underpins the place of performance rule, the Article 9.3 rule in the Rome Regulation, and the illegality by the law of the place of performance rule in law systems which followed the old common law. Yeah.
Got a question going back to the moratorium point about, well, surely if the in that case, Argentine banks, if are they still breaching their moratorium by government?
Absolutely. Absolutely. If an Argentine corporation subject to Argentine moratoria by the Argentine government were to make a payment pursuant to a decree of a New York court enforcing a New York law-controlled obligation, if the Argentine central bank or corporation complies with the New York court order, it's in breach of Argentine regulations. If it doesn't comply with the New York court order, it's in breach of New York court orders and therefore in contempt of court.
So what happened?
Nothing, because it was done in a much more effective way. The lawyers go out of it, and what the investment banks and others did was to freeze the assets of the Argentine corporations who refused to make the payments in accordance with the New York court judgment. And this is a fundamental of the practicalities of international finance. People always say, well, how do you enforce this stuff? Answer, easy. You're not going after Argentina's oil pipelines or its oil rigs. Nobody wants them. You can't even sell them anyway. What banks especially and hedge funds and others will go after are liquid assets. Next question, where are these liquid assets of major corporations and major banks? Answer is very straightforward. They're held in about 5 places. New York, London, Zurich, Tokyo, Frankfurt, Paris, Singapore, Hong Kong. All those assets are available for seizure. So as a practicality, it's not very difficult to enforce court orders. You're not going to Kazakhstan to seize the mines. You're not going to Argentina or Mexico, when it happened to Mexico, Mexican moratorium, to seize the oil pipelines or the oil rigs. Straight answer, banks can't sell them. Yeah?
We talked to answer the American hedge fund guy, Paul Siegenweg.
We'll come across it again, because the American hedge funds, the Paulson hedge funds, were involved in actually litigating this to enforce their payment rights. We'll come to that later when we do syndicated loans and bonds. Okay, right, good. I'm making good progress today. Any questions? Or are you clear, unclear, lost the plot? Okay. So that's the first rule applicable in relation to moratoria and exchange control. How far does the governing law, the expressly chosen governing law, control the transaction to the exclusion of governmental moratoria, which seeks to interfere with the payment obligations in an international financial transaction? And like I said, the answer is extremely strong. No, there's no possibility of interference if the law system that is being applied is New York or English law. It's one of the main reasons why these two law systems are actually chosen. Now, moving on, there's something else that needs to be dealt with in relation to moratoria, and that's the IMF agreement. Anybody knows what the IMF is? Well, at least you know that, right? It still exists, so you should know about it. Anyone doesn't know what the IMF is? Go on, tell me if you don't. This is the International Monetary Fund. It lends funds to countries in financial difficulty. Argentina, one, Greece, two, and many others. But it also has as its base the treaty which set it up, what is called the Bretton Woods Agreement or the IMF Agreement. The IMF Agreement and its entire provisions, without amendment, are part of the law systems of every country which is a member of the IMF. Who's a member of the IMF? Everybody. Give or take Vanuatu. You know what Vanuatu is? Vanuatu is a little island somewhere in the middle of the Pacific. Fantastic place for holidays. Great beaches. You've never been there. Well, take your next holiday in Vanuatu. But they're not a member of the IMF. But apart from that, everybody else is. So this rule that I'm about to talk about is part of the law system of every country on the planet, basically. And therefore, whatever law system you choose as your governing law, Article 8.2b applies. And what Article 8.2b applies has relevance to the question of moratoria. It says, I'm quoting the entire section, article, word by word. It says, exchange contracts which involve the currency of any member state that is, and which are contrary to the exchange control regulations of any member state, maintained or imposed consistently with this agreement, i.e. the IMF agreement, shall be unenforceable in the territories of member states of the IMF. In other words, if there's an exchange contracts which involve the currency of any member state and which are contrary to the exchange control regulations of that member state, then those contracts are unenforceable in every country which is a member of the IMF. So let's translate that back into a real-life scenario. It means, for example, that if you take a bond issue, payment obligations to be made in dollars, Argentina imposes a moratorium and says, no payment obligation shall be complied with, no payment shall be made in dollars. Now you've got to start looking at Article 8.2b. You've gone through that palaver about place of performance governing law, and you said, no problem. Argentine corporations must pay. And then an Argentine will say, hang on, how about Article 8.2b of the IMF agreement? Exchange contracts involving the currency of any member, contrary to the exchange control regulations of any member, obviously contrary to Argentine exchange control regulations, shall be unenforceable in the territories of any member, i.e. every member of the IMF must give effect to exchange control regulations of the member imposing it. So how does this work in the context of what we're looking at? Meaning, you've got an expressly chosen governing law, New York law, English law, or whatever law system you've chosen. How do you apply Article 8.2b? Is the law system now required, if its country is a member of the IMF, which of course the United States is for the moment, unless Mr. Trump pulls it out, the United Kingdom certainly is, and every other country in the world happens to be. Does it mean that Argentine regulations must be given effect to, and anything that contravenes Argentine regulations unenforceable in the member states of the IMF? Did you have a question? You preempted me. Now, there's a series of cases, both in the UK and in New York, which have analyzed and interpreted Article 8.2b of the IMF in relation to moratoria imposed by Argentina, by Russia, and all the other countries which have imposed moratoria. The interpretation of the English and New York courts, both of which were actually in 1983, one in England, UCM and the Royal Bank of Canada, and in the US, Libra Bank and Banco Nacional de Costa Rica, came to exactly the same conclusion. This is as if they've just phoned each other before the judgment. What they said was, Article 8.2b of the IMF applies only if there is an exchange contract. That was the point I think you were making. And in the view of the English and New York courts, loans, bonds, and any other transaction which does not involve the exchange of one currency for another is not within Article 8.2b, which means all international financial transactions, give or take one type of derivative contract, falls completely outside Article 8.2b in the view of the English and New York courts. So Argentina, for example, was not permitted to plead Article 8.2b in the New York courts. UCM was not allowed to plead Article 8.2b in the English courts when pursued by Royal Bank of Canada. And therefore, Article 8.2b is removed from creating uncertainty in the global financial markets. It's a huge milestone, moving Article 8.2b out of the realm of applicability in relation to loans, bonds, securitizations, and just about every other type of transaction that you see in the global markets. The second reason advanced by both the UK courts and the US courts in New York, applying New York law, was this, that Article 8.2b requires that the exchange control regulations, let me take you back to the language, exchange contracts which involve the currency of any member state and which are contrary to the exchange controls of that member. New York courts and the English courts said, hang on, Argentine regulations are concerned not with the Argentine peso, but with the US dollar. No payments in US dollars. Therefore, said the US courts, Article 8.2b does not apply because the exchange contract does not involve the currency of Argentina. That's the language of that provision. Therefore, Article 8.2b, for the second reason, does not apply to a moratorium imposed by a government in the context of financial difficulties that they have. That's quite a harsh ruling, and it was criticized heavily, but if you read the judgments of the courts, the reason why they say is that's the conclusion is very simple. You read the text. It's like Bill Clinton, read my lips. This is read the text of Article 8.2b. And that brings me right back to talking about something I mentioned about a week ago. The conclusions, sorry, hang on, where is it now? Yes. That the New York courts and the English courts have come to is completely different from the conclusions arrived at in relation to Article 8.2b by the French, Italian, Japanese, and Dutch courts and German courts. The reason for the difference in interpretation is very important, and I think it's something that we need to understand. What the French, the Italian, the German, and Japanese courts decided was this, that you cannot read Article 8.2b in the way that the English and New York courts have done, i.e. literally, word for word. You have to look at, said these courts, the purpose of Article 8.2b. The purpose of Article 8.2b is to try and help a country in financial difficulty to get over those difficulties by enabling that country to stop making payments in dollars, euros, or any other hard currency. Therefore, Article 8.2b is triggered whenever any contract involves the financial reserves of a member state. That is a very, very different approach. And the difference is straightforward. And this is why earlier on, 2 weeks ago, I talked about the very different approach of the common law-based systems and the Napoleonic and the Romano-Germanic systems. The Romano-Germanic systems will look at the purpose of a legislation, will look at the purpose of a regulation, will look at the purpose of a contractual clause. English and New York courts will not look at purpose. The only question is, what have you written? Read the text. End. So if you read the text, then the English and New York courts are absolutely right. Exchange contracts are not syndicated loans. Exchange contracts are not international bonds. They're not securitizations. And therefore, they come to the conclusion that Article 8.2b has absolutely no application to our world of international finance. But that's not the end of the story because of the fact that the German courts and others have gone in a different way. Now, 20 years ago, the German Federal Court was faced again with this Article 8.2b problem. And this was once again in relation to bonds and loans in the markets. And there the German court kind of moved away from its very strict application and saying, yeah, we will recognize the moratorium under Article 8.2b. What they said was, in the two judgments in 1994 and 1997, was that in relation to what they called capital account transactions, Article 8.2b would have no application. But in relation to current account transactions, it would. So, in relation, what are capital account transactions? That involves the movement of funds, current funds, by way of loans or bonds for periods of time over 1 year. And that means essentially what the German courts have decided in the last 20 years is that the position under German law applying Article 8.2b is similar to New York law and English law. Namely, Article 8.2b has no application if one is looking at what is called the capital account, namely bonds or loans, if you want to bring it down to straightforward practical conclusions, but would apply outside those two areas. That kind of puts German law in relation to Article 8.2b somewhere in between English and New York law on the one side and French law, Italian law, Japanese law on the other. Anybody from Germany? No, of course there are no German laws, I know. I sometimes think, where do you come from? Nobody from France, nobody from Italy, nobody from China, nobody from Japan. So where do you guys come from? Vanuatu? I know, whenever you're going to ask a question about a law system, nobody comes from that part of the world. Okay, so that's Article 8.2b. And it is an important aspect of international finance that the two law systems which are chosen to govern international financial transactions have clearly, and this is why I use the word aggressive approach, determined that Article 8.2b, which is in place to help countries in financial difficulty, actually has no application when a country imposes a moratorium because they are in financial difficulty, because of the language of Article 8.2b. Any questions, or can I move on? Yeah.
Just to clarify, although we have a difference between moratorium and exchange control regulations, under Article 8.2b, they both fall under the same terminology, exchange
Control regulations, because the reason is a moratorium is no more than an exchange control regulation enacted after a transaction has been entered into. Exchange control regulations exist all the time in many countries, I would say most countries, outside the EU, Japan, and the US or Canada. But it's when an exchange control regulation is enacted preventing payments on existing payment obligations under an express governing law that the problem becomes a different one. It's a moratorium seeking to interfere with existing payment obligations. Right, good. Any other questions? Yep. Yes, but let's do that in Finance 3, shall we? You're absolutely right. A currency swap falls within Article 8.2b in accordance with the New York law and English law rulings. Yes, absolutely. But we'll come to that. I mean, that's why I said with one exception in derivatives. That's the exception, currency swaps. So that's the second set of rules which we need to worry about and ask the question, do these rules, the Article 8.2b rules, override the governing law? And the answer is, depends on the governing law. If it's English or New York law, the answer is no, it doesn't. If it's French, Italian, Japanese, answer is yes. If it's German law, it's maybe, depending on the type of transaction one is looking at. Finally, we need to look at moratoria in the context of something called the Acta State doctrine. Now, the active state doctrine is a common law doctrine. I've checked with French global law firms and German global law firms, and they're not quite sure whether there is a comparable rule in their law system. What the rule is this, and it's a common law rule, applicable both in New York and in the UK. It is this, that a court in the US or in the UK will not challenge, will not question the legislative act or a regulation of a foreign sovereign state. Note, it applies only to foreign sovereign states, and basically the rule is if you are an English court or a New York court, you cannot question the effectiveness and the validity of a legislation or a regulation of a foreign sovereign state. So, if you stop the clock there and say, well, hang on, Argentine moratorium, Russian moratorium, what should an English court or a New York court do? The first reaction is to say, well, an English and New York court must recognize that moratorium under the Act of State doctrine. But the matter has come before the New York courts and the English courts. New York courts in the Libra Bank case again, it was argued there, Banco Nacional de Costa Rica in 1983. And again in the Allied Bank International case, Banco Credito Agricola de Cartago, and then in English law, in Butts, Oil, Gas, and Hammer. What the two sets of courts said, meaning English courts and New York courts, said exactly the same thing, but let's summarize it. What the two sets of courts said was that the Act of State doctrine, which would prevent a court from questioning an Argentine moratorium or a Russian moratorium or anybody else's moratorium, applies only if the assets which are affected by the moratorium are located within the jurisdiction of the sovereign state imposing that moratorium. That's the rule. Let's try and understand it in a minute. The rule is, unless the assets which are to be affected by the moratorium are located within the jurisdiction of the sovereign state imposing the moratorium, English and New York law will not apply the Act of State doctrine. So let's go back to Argentina, or Russia for that matter. Loans or bonds governed by English or New York law in the case of Argentina, English law in the case of Russia. Payment obligations in the case of Argentina, payable in New York, payment obligation in the case of Russia, payable in London. Russian moratorium saying, no, you will not pay dollars under these loan agreements. And the Argentine moratorium saying, no, you will not pay dollars under these loan agreements. Now let's apply this rule. Where are the assets located? Now assets here is not referring to the oil pipelines or the oil rigs or the factories. What we're looking at is the asset with which the moratorium is seeking, attempting to interfere with. What is that asset? It's the payment that has to be made. In whose hands is that an asset? In the hands of the creditor or the banks, if it's a syndicated loan, bond investors, if it's a bond. They've got the asset in their hands, the payment obligation of Argentina or Russia, just to take an example. Next question, where is that asset located? That depends on where must the payment obligation be performed. The Argentine payment obligations in dollars were performable, must be performed in New York. The Russian payment obligations had to be performed in London. Therefore, said the courts, the American courts were dealing with the Costa Rican moratorium, not Argentine, but the rule is very much the same. They said the right to payment of the syndicate banks, which had made syndicated loans to corporations and banks in Costa Rica, they were payable in New York. The right to receive interest or principal was in New York. Therefore, said the court, the asset is located in New York, not in Costa Rica. Therefore, said the New York courts, the act of state doctrine doesn't apply. And we don't need to recognize the Costa Rican moratorium. If the payment was to be made in Costa Rica, then of course the asset, the right to payment would have been in Costa Rica, and therefore it would have been within the jurisdiction of the Costa Rican government. But that was not the case. The asset, the right to payment of the banks was located in New York. Therefore, said the courts in two cases, the act of state doctrine doesn't apply in this scenario. Now, if you think about this, step back and think about it, it simply means that if the place of performance of a payment obligation is outside a country imposing a moratorium, whether the payment obligation is performable in Tokyo, Frankfurt, London, New York, wherever, Singapore, whatever, it only means one thing, that the government imposing the moratorium is attempting to interfere with an asset located outside its jurisdiction, its territorial jurisdiction. Costa Rica is Costa Rica, Singapore is Singapore. They're seeking to interfere with an asset in Singapore or in London. Therefore, said the courts in London and New York, they will not apply the act of state doctrine to recognize the moratorium. A bit of history. This is all based on a case in 1848 where the Duke of Brunswick was having a ding-dong with the King of Hanover. And the English court said, no, we can't apply the act of state doctrine because the asset is located outside the control of the Duke of Brunswick. Anyway, that's 1848. We're now in 2018. So that's basically the rule, but now let's try and bring it back into practice. One more reason why the place of payment, payment obligations of interest and principal in relation to bonds or loans, in practice is expressly located in a major financial center outside the home state of the borrower in relation to the loan or the bond or any other transaction, which means that the act of state doctrine doesn't apply. If you now put it all together, if the payment obligation is outside the home state of the borrower, the issue of the bonds, Rome 1, Article 9.3 does not apply. 2, Article 8.2b of the IMF does not apply. 3, the act of state doctrine doesn't apply. Conclusion, payment obligation is enforceable, at least under English and New York law. That is a very aggressive stance taken by both the English courts and the New York courts in relation to payment obligations in international finance. Many have criticized it on the basis that it is really a harsh interpretation of the law. It's unfair on countries in financial difficulty and we've got to impose moratoria. The answer given by the New York courts and the English courts is as follows. You have undertaken solemnly an international financial obligation. If a country can interfere with those obligations easily, what happens to the lifeblood of international finance? It suffers a heart attack. It comes to a grinding halt. You can't allow everybody to start imposing moratoria and interfere with the global markets, because the global markets will then stop functioning. People who want to lend will say, no, I don't want to lend. Now there are rules which enable the enforcement of those solemnly undertaken obligations. That's the logic that the English and New York courts have adopted. I'm not saying it's right, but that's the approach. And yay, I've got 7 minutes and I've finished that topic. Next week, I'm going to get on to syndicated loans, the first of your transactional lectures. What I'm going to do, by the way, I'm going to give you a fact pattern analysis which will include all of this stuff, plus a bit of syndicated loans, which I will hopefully cover next week. And so the seminars which will look at these fact patterns and discuss them will commence the week after. Not next week, but the week after. Are we clear on that? I don't want to see emails saying, I came to the seminar and there was nobody there. Okay? I'm not there and nobody else will be there either next week. The seminar group list will be up on Keats, I hope, by Thursday. Thursday? Hang on, that's tomorrow. Yeah, tomorrow. Okay, so you'll know which group you're in and what you have to do. All right? And the seminar question will also be on Facebook, Instagram, whatever. Any questions, guys, before I take off? No? No questions? Okay. Done.
Two questions actually. One is seems very simple one. Practice module, when will you know whether we'll be able to take it or not?
Hopefully in about 2 or 3 weeks' time.
Okay. And secondly, with respect to the moratoria of Argentina. So, obviously Argentinian law prohibited the Argentinian entities from making payments.
Yep.
Whereas since it was governed by New York law, obviously they have to make payments. But if they decide to, which they probably did, ignore New York law, it's only enforcing it under Argentinian law, which is recognized by Argentinian courts, no? Since the corporations are Argentinian.
Like I said, I don't think you were listening.
I did answer of
The location of the liquid assets which people would go after are located outside Argentina. There is no hope whatsoever of enforcing the payment obligation in Argentina, of course not. But importantly, one, the payment obligation is located outside Argentina and it's enforceable by the courts where there's no, in the case.
That would be my sentence. So basically,
Yeah.
it would still rely on the courts of where the liquid assets are located.
Yeah, exactly.
And if they refuse to enforce it,
Exactly. And you come right back to whether New York judgments are recognized in Geneva or Zurich or in Tokyo. And the answer is yes and yes.
that's our sort of confidence.
No worries. Okay. Hi.
I didn't make the question properly. What I was meaning is that in Article 14 of the Rome Convention, Rome 2.
Rome Convention or Rome Regulation 2?
Rome Regulation 2.
Okay.
I read that the choice of law must be expressed with or demonstrated with reasonable certainty, and that this choice cannot affect the rights of the parties.
Right, so third part.
Oh, third parties. Sorry. The question is this is not predictable, highly predictable, and
Well, it is because
so-
if someone who suffered loss is suing, for example, on the basis of misinformation, if you proceed, we look at this in detail as to, in a fact scenario, against the issue of that information. Therefore, what that article is saying is, if you two agree, the issue of the information and the recipient of the information agree that any misinformation will be dealt with under the following law, well, that's it. But it won't affect the rights of parties who are not party to that agreement.
that in good faith trust that agreement.
No, it's nothing to do with good faith. If they are not party to that agreement, they are not affected. They are called third parties.
By the way, when I read reasonable certainty, reasonable is you told
Well,
us
I mean,
that
you can, of course, it's to be indicated with reasonable certainty, i.e., it's not to be found in some napkin at a restaurant where you went to, but it's in a formal agreement. Yeah, expressly. If it's expressly stated, well, it's expressed with certainty. All right, okay. Hi.
I sent you an email 2 weeks ago
What about?
about you asked me to send about the what's our dissertation about finding a.
Oh my God, you're right, and I have completely
But
forgotten.
I just.
I will attend to it.
If I wrote something wrong.
Well, no, not, I'm sorry. This is me. I mean, my email box is just.
Yeah,
full.
I figured so. Just.
What do you want to write on again?
Sorry.
What do you want to write on?
I want to write about the derivatives in credit houses. With the,
I know. Now I remember. Because, I mean, our problem is there isn't anybody in the school who can do this, to look at derivatives. Can you pick something else?
Probably, but it's an interesting.
Not something you're interested in.
It's because the Norwegian car trader kind of
put the clearance system to a test and it shows that.
I mean, the only person who might be able to help you is Professor Michael Schillig.
Okay, yeah.
He's a professor who teaches bank restructuring and that kind of stuff. So he may have a sufficient knowledge to actually deal with the clearance systems. Yeah, have a word with him and see what happens.
Yeah.
And let me know. The second person you might want to talk to is Dr. Federico Ortino, who is also in finance, deals with investment law rather than anything else. But have a word with both of them. Yeah?
Great, thank you.
Okay.
Will you be able to have the Finance 2 module or?
I don't know yet. I know. I said 4 weeks, so give me another 2.
Yeah, sorry. I just have to do some.
I will.
Sort it out some way.
Okay.
If you're able. So.
Okay, I will. Hi. Hi, Michael.
Just a quick question about
Mhm.
the Libyan case. I was wondering why.
Why don't you guys ask questions from the floor? Give me an answer, because what I'm trying to do is to deal with
Maybe it's a silly question.
No, it's not. I think the important thing is that when questions are answered asked from the floor, the answers go right across the class, and people who might have had the same question, otherwise it's just endless one-to-one. And I bet you one of them will ask the same question. So go ahead.
So in the Libyan case, I was just wondering why did they